these is MNC Investama. This is an investment company and it's listed on the Indonesian Stock Exchange. It holds interest in various industries, including media, financial services, lifestyle property, and energy through various subsidiaries. In 2018, MNC issued $231 million worth of 9% senior secured notes due in May 2021. These notes are listed on the Stock Exchange of Singapore. In light of the COVID pandemic and the economic downturn, MNC faced difficulty meeting its obligations under the notes. It therefore sought to propose a scheme of arrangement under Section 210(1) of the Singapore Companies Act to restructure the notes. It first sought a moratorium under Section 211B of the Companies Act. We successfully obtained a 2-month extension of the moratorium. The extension provided MNC with the necessary breathing space to restructure its notes and allow it to engage the note holders on the proposed terms of the restructuring. This was extremely successful and the scheme was sanctioned earlier this year. Now, there are a couple of significant points I wanted to highlight with respect to this case. The first is the substantial connection test. In order for a foreign company to be able to utilize the Singapore restructuring regime, it has to show substantial connection to Singapore. Now, this is the first known case by an Indonesian company applying for a moratorium under our Singapore Companies Act. In this case, the judge actually issued a decision, and it's published, where the court addressed the question of whether a foreign company has the requisite standing to apply for a Section 211B moratorium. The decision provides useful insights as to the factors that the court will take into account when determining whether a company has substantial connection with Singapore. In particular, this case clarifies that the Companies Act does not provide an exhaustive list, and having securities traded on a Singapore exchange would in and of itself be sufficient to establish a substantial connection with Singapore. So from this, we can gather that the threshold is therefore very low, and this can be seen as a clear invitation for foreign companies to consider Singapore as a jurisdiction to restructure their debts. I'll move on now to the second significant factor of this case, which is the prepackaged scheme of arrangement. The prepack scheme procedure is a relatively new feature introduced in May 2017. Now, what is this? The prepackaged scheme basically truncates the normal scheme process in that the applicant may dispense with both the court hearing for leave to convene a meeting of the creditors and the meeting itself. However, the applicant would still have to satisfy the court that had a meeting of the creditors been summoned, a majority number representing 75% in value would have voted in favor of the scheme. We used this provision to our client's advantage in MNC. So in our case, what we did was MNC issued a scheme document and then held an information meeting to explain the scheme to the note holders and to take questions. Thereafter, it solicited for the note holders' proofs of claims and votes. A verification meeting was subsequently convened to announce the voting results, and a court application was made to sanction the scheme. In view of the fact that we had achieved the requisite majority, which is a majority in number representing 3/4 in value of the scheme creditors, the court accepted that the company had satisfied that the requisite majority had been met and therefore sanctioned the scheme. This is the first known sanction of a prepackaged scheme by the Singapore courts for a foreign company under Section 71 of the newly minted Insolvency, Restructuring and Dissolution Act. We had been very happy with the result because the prepackaged scheme saved significant costs and time associated with convening of a scheme meeting for MNC. In fact, from the commencement of the proceedings by way of filing for the moratorium to the sanction of the scheme, this took about 8 months.